Cristina Hintalan sent us an email regarding her problem with her deceased parents' property, which is currently under the possession of strangers. According to Cristina, her father suffered from a prolonged illness when he was still alive. They decided to get a caregiver for their father, who in turn lived in their father's house. Since the caregiver became very close to them, they even called her Mama. The caregiver lived in their father's house for more than 30 years and in fact allowed some of her nephews to live in Cristina's father's house. When their father passed away, the caregiver also died a few months after. It was at that time that Cristina transferred the title of her father's property to her name. Her problems: the nephews of the caregiver refused to leave the property and were asking her to pay them 200,000 pesos. She initiated an ejectment case against these people, but according to Cristina, she lost the case on the ground that she failed to show compliance with the jurisdictional requirements for the filing of an ejectment case. According to Cristina, they again paid a lawyer to file another case. She is asking if the land will be granted in her favor since she is the registered owner of the property. Cristina, it must be remembered that the only issue for resolution in an unlawful detainer case is physical or material possession of the property involved, independent of any claim of ownership by any of the party litigants. Moreover, an ejectment suit is summary in nature and is not susceptible to circumvention by the simple expedient of asserting ownership over the property. There are a number of feasible reasons why your ejectment case was dismissed. It could be that the court found that any of the following jurisdictional requirements were not met, such as those enumerated in the Cabrera versus Hetaruela case. First, initially, the possession of property by the defendant was by contract with or by tolerance of the plaintiff. Eventually, such possession became illegal upon notice by plaintiff to defendant of the termination of the latter's right of possession. Third, the defendant remained in possession of the property and deprived the plaintiff the enjoyment thereof. And fourth, within 1 year from the last demand on defendant to vacate the property, the plaintiff instituted the complaint for ejectment. It is our humble opinion that you may consider filing a case for action publicana. In the case of Spouses Valdez Jr. versus Court of Appeals, it was defined as the plenary action to recover the right of possession, which should be brought in the proper regional trial court when dispossession has lasted for more than 1 year. It is an ordinary civil proceeding to determine the better right of possession of realty independently of title. In other words, if at the time of the filing of the complaint more than 1 year had elapsed since defendant had turned plaintiff out of possession or defendant's possession had become illegal, the action will be not one of forcible entry or illegal detainer, but an action publicana. Thank you for your trust in People's Television. Please remember that our opinion is based solely on the information you provided us. You are free to consult a lawyer of your choice regarding concerns. Email us at ptv4newscenter@gmail.com. Attorney Jimeno Atienza for the Rule of Law.